Part two of the most common questions people recently asked me in comment section after my live interview. Question number 5. What happens to our house when we get divorced? By the way, there is a 1-hour video on my divorceacademy.org website that includes what happens to my house when we get divorced from all perspectives. From financial planner perspective, financial planner is there, real estate agent perspective, mortgage broker perspective, divorce attorney me perspective, and that video is very long, so I will touch upon the main points. Either the house can be sold. It's called division in kind, which means one spouse has 1 million in assets, in liquid assets, and the other spouse wants to keep the house, and the house is $2 million, then the spouse keeps their money and buys the other spouse out of the house. So, buyout option. People wonder, well, in a buyout option, what value do we take? We take current market value minus all liabilities. And some people would like to reduce the current market value by the percentage that they would pay to a real estate agent, for example, 6% or 3%, whatever. They agreed, but if the house is not sold, the court will not allow to reduce the current market value with liabilities that are not there. So no tax liabilities can be taken, no real estate. So it's pure current market value. And usually people hire appraisers or get opinion from real estate agents who are specializing in giving opinion about values, minus mortgage. And if there is a second mortgage, HELOC, and that will be the current market net value. Then the spouse who keeps that house would need to be 100% responsible to pay for the mortgage, property tax, and all carrying costs, obviously, for the house, and take the other spouse from the title. In the buyout option right now, when the percentage is so high, it's really, really tough to refinance because it doesn't make any sense. For example, if the spouse has 3-point-something% on a mortgage payment, right now 6-7% wouldn't make sense. So what parties can agree is deferred situation. It could be deferred sale or deferred refinance situation. So for the spouse who is buying out, it has to make sense. So maybe they get a higher value in exchange for staying on the liability portion of the home or even on the title. So buyout option is option number 1. Second option, to sell it, which is least favorable option in divorce cases because you have to pay all these staging fees and taxes. Each party gets $250,000 tax exemption on the gain tax. So both parties get $500,000. So if the home was 1 million and now they're selling for 1,500,000, then they don't need to pay gain tax because 500 is exempt. But they need to live in the house 3 years prior to selling it. And in that longer video, there are more exceptions where the other spouse doesn't need to live in the home. So I will defer to that video for more details. But that's the basic understanding of the tax exemption. So both parties sell, they reduct everything that is liability, staging, real estate agent, and then the net amount can be also divided in kind. So either 50-50 or whatever they agree. I suggest to have financial planner do this because retirement assets are not the same as cash, because retirement assets, if you cash out, it will lose in value approximately 30 to 38% for taxes and penalties. You cannot just liquidate retirement. So it has different calculation method than cash, checking account, investment account. And then if you divide stocks, you have different age category of stock. So stock that was bought 2 years ago has less, the gain tax is only 20%, but stock bought half a year ago has income tax rate, which could be higher. So there are a lot of nuances that people can not know unless they're speaking to a professional financial planner, specifically helping them in the divorce, who will create a list of assets and debt split. And the way we split assets and debt is as of the date of separation plus increase in value. So we take the home value closest to the date of settlement. Checking account we take as of the date of separation, because checking accounts usually don't grow in value. So first option, what happens to the house? We have buyout, sell, or the third option, deferred sell or deferred refinancing. Next question. Question number 6. How are debts divided in divorce? Debts are, as assets, divided equally. So we look at the date of marriage, the date of separation, and the date of separation is the date when one spouse, just one, decides, I'm done, communicates it and to the other spouse and acts accordingly, meaning no traveling together, no sleeping together, no acting like husband and wife or husband and wife, you know what I mean? Not acting like they're married. That's considered the date of separation, not the date you file for divorce, not the date you file for legal separation, not the date someone moves out. Moving out is no longer necessary. This has been litigated for a long time, up until Supreme Court. California doesn't look, it's expensive to live in California, and not everyone has to move out. So date of separation has two factors: objective factor, meaning it appears that they both live like roommates, and subjective factor, one spouse decided the marriage is irreconcilable. Date of separation, we look at what are the debts. It could be credit card debts, home debts, any debts. Student loan debts are assigned to the spouse who had them before marriage or during marriage, unless the community benefited from it. So, for example, if someone took a student loan debt and then became a doctor, and now that doctor is supporting the entire family, then it could be argued that some of this debt is community liability because community is now benefiting from the salary of a doctor. What do we do with debts that are really not acceptable? For example, prostitutes, gambling. The court, in 12 years, I had that happen twice. It never went to actual trial. The theory is that the spouse who didn't know and didn't approve of that debt shouldn't be responsible. But usually what happens is that spouse who claims that the other spouse spent on prostitute and gambling has to prove it. And that becomes a big issue. How can you prove that someone spent money on prostitutes? Because usually what happens, they go and take ATM money and then they take cash out and then they pay. And then sometimes they have some text messages exchanges that can be linked to that ATM transfer. But imagine I have a client who claims that the other spouse spent $400,000 on prostitutes. And how can you go through, if the prostitute was $1,000, 400,000 transactions? That's impossible unless there is a huge level of discovery that the other spouse needs to answer, request admissions, admit that you spent that on prostitute, and the other spouse says, no, I didn't. And then if you prove that he did, then you automatically get attorney's fees reimbursed. But that's really very, very rare. What is less rare is when some spouses send money to their parents outside of America. And that's easier to prove through the bank transactions. That's why it's very important to look at all the bank transactions throughout the marriage, not just what California law requires so-called preliminary declaration of disclosures, meaning the current one, because the spouse who was planning for divorce could have shuffled money offshore to parents, transfer them out. You would be able to see in the bank transactions. Sometimes they don't disclose the banks. I had a case where I had to hire a private investigator because it didn't make sense that this person was broke. And I found $300,000 in a bank account that he didn't disclose. And we were able to get half of that money and plus sanctions, 20,000. So this is important to know that all debts are divided equally, unless whoever claims that the debt shouldn't be divided equally, the other spouse should be responsible. Then if they claim that they are responsible, to prove it, which is another level of expenses for attorney's fees, discovery, and all of that. So question number 7, can I get divorced without a lawyer? This is a good question because on one hand, I'm a lawyer and it's almost like asking a doctor, can I have an operation on my appendix or something without a doctor? Well, in that case, no, for sure. But I would say either way, better to have a lawyer than not. Why? I had a case where he was a truck driver. She was a homestay mom, and he had the money to hire a lawyer, but he decided not to and hired a paralegal. And they agreed. So they agreed that they exchanged financial disclosures, and they wrote it in the marital settlement agreement. And they also said that spousal support is waived. The court has no jurisdiction towards spousal support. But they forgot to write that spousal support is not modifiable. So what happened is she hired a lawyer. After she found out he has a girlfriend and actually drives now a new car, and that lawyer sent a subpoena to the car dealer to see how he got the car and how much he claimed he makes. Literally within 6 months from his divorce, he claimed to make 5x than what he claimed to her. And then when he hired me, what turned out to be the problem is that although they signed a document by paralegal that was very inexpensive to say that they exchanged preliminary declaration of disclosures, they actually had no proof that they did. And when I represent clients, I make sure I send an email with the whole financial disclosure so she cannot claim or he cannot claim that they didn't get it. And that's number one reason for setting aside a judgment. And that was one reason. The second reason is she asked for spousal support. When she asked for spousal support, the agreement didn't say it's non-modifiable. It said the court doesn't have jurisdiction, but it didn't say that the court has no jurisdiction to award, modify, and no court is allowed to even give. I mean, the language was very inaccurate and it had loopholes. And the other spouse, she used that agreement was loopholes to get her spousal support. So at the end, the retainer was expensive, like $8,000 retainer. One attorney then declined representation, then the second attorney, then the third attorney. So that man saved $2,000, but not saved. He paid $2,000 to paralegal. So he saved maybe $3 because the whole agreement during that time could have been $5,000. But now he spent over $30,000 to fight. And then eventually this case became just never ending, her asking for more. And the moral of the story is, who said it? Lincoln? You are a fool if you're your own client. Something like that. I will put it here on the screen. So if you're representing yourself, you're a fool of a client. So I would never represent myself, even as an attorney. So that tells you something. And other less extreme examples are people just do this paperwork and then it gets bounced and it takes so long. I personally, I have to change my will, only the name, in will and trust agreement. And I thought I can do it myself. I'm a lawyer. I can do it. 6 months later, I haven't done it. So procrastination means delegation. So another thing why I would hire an attorney, because things get done, right? So even though I technically could do it, I procrastinate. So that means I need to delegate. Final question for this video, to not make it too long. How long does divorce process take? This is a really loaded question because, in pregnancy, we know the pregnancy usually takes 9 months, but its biological process is programmed. Divorce is not like that rigid. So divorce could be 6 months, 9 months. The longest divorce I have seen, and that's just unicorn kind of divorce, is 8 years in a 14-year marriage. Because a lot of assets are involved, complexity, children, homes, venture capital, carry interest. I mean, it's just super, super complicated. And if one spouse has an addiction, that makes the process even harder. If one spouse keeps changing lawyers, that delays things even more. So I took 100 clients over 1 year, and I looked at the average divorce process timing, and it was about 9 months, coincidentally with the time it takes the pregnancy. It wasn't on purpose, but some divorces were, the shortest divorce I had was 1 month, meaning she contacted me. I did all the paperwork. 30 days after he got served, he didn't respond. I had already default judgment ready to go. I filed it, and I got it almost within 2 weeks. So I would say it was not 1 month, but 6 weeks. And the paperwork said she's single, they're single, 6 months and 1 day from the date that he was served with the divorce paperwork. That was the shortest. The longest one was 8 years, but both are unicorns. So the truth is somewhere in the middle. The court processing time is typically, once the divorce package is submitted, is typically up to 3 months, depending on what time of the year it's submitted. So you can assess that the court processing time and your time are different, right? So for example, if both parties are cooperating, they're providing, one spouse filed for divorce, served, they exchange preliminary declaration of disclosures. My turnaround time for creating an agreement is 1 week. So during the agreement, submitting the judgment package, that alone can take a couple weeks. And if that is done very, very quickly, the turnaround time will depend on you. It becomes problematic when someone is asking for things that needs to be decided by the court, because when we file a request for order, the court will set a hearing date in 6 weeks, and then it gets continued, and then it can be a trial, and then the trial will be set in 1 year. And it just, ideally, if both of you are interested to resolve the case quickly without court, and you cannot reach an agreement, hire a mediator, with each having an attorney on each side, because mediator will not usually settle the case in 1 day unless the mediator advises you to contact and consult an attorney, each of you independently. That's a duty of a mediator, and that delays things. So I had a client who's a lawyer, or I had a client who's a, because now it's gone and it's a divorce and all done. But he said, "Oh, I will get a mediator, so I will need your help with paperwork." I'm like, "Okay, fine." A year later, he comes back and says, "It didn't work out. This mediation was dragging on and on and on." And so what I did, I scheduled mediation in a month, and we settled in 1 day and signed a marital settlement agreement, and all the judgment paperwork was done within a week after. So that was resolved quickly. But in order to prepare for that mediation, you gotta have your cards on the table, meaning you have to know what's involved, how much assets, how much debt. Have a personal financial advisor planner create a spreadsheet of all assets and debts divided, retirement accounts. All of that needs to be ready so that the agreements, whether to buy out of spousal support or buy out of the home, that can be hashed out in the mediation. So the mediation is only effective if you are prepared. All right, I hope that was helpful. If you have any other questions, ask down in the comment section below. I will do a third portion of Q&A videos, and the next video is going to be about questions. What are my rights if I think my spouse is hiding assets? How do I modify child custody or support orders after divorce? What would I do to prepare for divorce mediation? And how can I protect my business in divorce? I will see you in my next video, or check out my divorceacademy.org, where I will see you in my next consultation. Bye!